section.
Kalibara, Frederick Mpanga, Aaron Chisa. For A1 and A2, and for A3, Simon Nsubuga. For the state, Richard Biribumbuka, Chief State Attorney. These are
Court granted him permission to address court, but through writing. Which was supposed to be filed before the 3rd day of October 2025. Yeah, that's from my road. This honorable court will address the concerns of the accused person as addressing that road. Hello. Hello.
We are the ones to raise concerns. Yeah, but we have a senior counsel here, Martha Carol, who would ordinarily do that procedure.
And we are ready to proceed.
Which he filed such this month. This court had given the accused opportunity to put all his concerns in writing so that court is able to address them. Since he still wants to address court as per that letter, let him go ahead and raise his concerns.
Concerns we wish to raise are two very small concerns, and I'm grateful that you've granted us the opportunity to do so. We are not just being For example, if I want to communicate my anguish cannot be written, can only be seen on me. And so it's important that I speak and you capture how I look like. You can see what I feel. So, my Lord, on the first concern, just to give it a small background, it's a concern about our presence in this court. And the background is that we visited Nairobi, Kenya on the 16th of November last year as a normal visit through our airport here, through Jomo Kenyatta International Airport and into our hotel. But shortly thereafter, while at a meeting, we were grabbed by armed men who introduced themselves as Kenyan police, and we were instructed that we were under arrest. We were bundled from the meeting room into a vehicle. And apart from a short stop at a petrol station to fill their tank, the vehicle we were bundled in only stopped in Malaba, where after a short stop on the Uganda border, Uganda-Malaba police, where after a short while another vehicle came and we were put into it and driven straight to Makindye military barracks. So the first background to this is that we were really kidnapped and brought back to Uganda by force and detained in a military barracks. We are not soldiers. where we were held incommunicado for 4 days. So the history to our being here is that illegal rendition and detention in a military facility outside the law. From there, we were produced in the military court martial. A court martial that had been already declared unconstitutional several times by the Constitutional Court. So we were taken to a court that was illegal, and in the knowledge of the state that it was an illegal court. And it is that court that remanded us to Ruzira prison, where we still are. Of course, as everyone knows, the court was later on in January conclusively declared illegal, unconstitutional, and scrapped. We remained in illegal custody after the court had declared, the court that remanded us, as unconstitutional, because the remand warrant we were given, which took us to Ruzira, expired. We had expected that following that judgment, if they still wanted to prosecute us, they would take us to a prison, to a police station, and a new process would begin. But we remained in illegal detention until we were charged in Nakawa in February this year. It is the Nakawa court that indicted us. Yeah, it is the Nakawa court that indicted us on the 29th of May of this year. And I have a copy of the indictment here. I don't know whether it is different from what you have, my lord, or what prosecution has, or other people, because my indictment clearly states and this is on the 29th of May, that take notice that you will be tried, and that is the three of us, A1, A2, A3. Take notice that you will be tried on the above indictment at the sessions of the International Crimes Division of the High Court, beholden at so and so. So we were indicted to be tried at the International Crimes Division. Which is a division of the High Court that is very different from this one by composition and by its processes, the procedures. So, and the reason I give the background of the illegality that we have faced in the last about 1 year is that we seem to be in another wrong court. And we don't know whether this is part of, again, a process that will just keep us delaying to have this matter disposed of. The second matter, my Lord, is that before the summons or the warrant to bring us for beginning this trial, we had appeared before you in a matter of our application for mandatory bail. And arising out of the ruling that you made, which ruling seriously stunned us. Because especially in your ruling, my Lord, you indicated that the court was not aware of matters to do with our earlier charges in the court martial, in the general court martial. There was no record of a charge sheet and the case number. There was no record of the remand that we were detained on. That all that was available to you was the case of Nakawa, and that since the court can't be an investigator to find out what happened before, you made the conclusions that you did. This was very disturbing because not only were all the documents and details of the general court martial process filed together with our application, the very affidavit that we saw, is myself and my colleague and friend here, Ajobeid Lutale, both affidavits indicated how we had been arrested in Nairobi, how we were brought to Kampala, how we were charged in the court martial and remanded. Sections of the affidavit that I am referring to were concurred with, were accepted as truth by the prosecution. They were not contested. But of course, on top of that, our lawyers here in open court made extensive reference to those very documents and to more than even what was filed. So, my Lord, we considered that your treatment of our application either showed we considered that either you are grossly incompetent, if you could not read what was on file before you, or at least biased, both of which we to be very serious matters, because we run to court, everybody looks at court as a temple of justice. And so, my Lord, we were compelled to file a complaint against you with the Uganda Judicial Service Commission And if you have not received a notification of that complaint by the Judicial Service Commission, as they are required to extend it to you, I'm sure you will receive it. And so these two issues tie up. In this case in which we are charged to be in another court, we end up still in your court. In fact, today, my Lord, apart from the intended commencement of a trial, you have set aside today to hear our second bail application today. This was the application we made in April of this year. But my Lord, in your ruling regarding the mandatory bail, you categorically stated that it is my considered view that priority be given to hearing the main case other than bail applications. In other words, you already have a view about bail applications, that they are useless. What is important is to hear the case. Have expressed that view in writing under the court seal. So that you also hear another bail application. Maybe that's why our case also ended up here instead of the court where it was supposed to be, so that you are sure now that the trial has begun and applications for bail are redundant. So in summary, my Lord, one, we seek to understand why we are not in the International Crimes Division, to where we were indicted. And two, whether And two, my lord, whether in light of what just said about my complaint, our complaint, my complaint and the complaint of my colleague Haj Obeid Rutale, against you, which complaint in fact seeks one of the things that it could achieve would be to remove you from the office of judge. Whether in those circumstances you consider that it is still prudent that you continue with the processes of establishing justice for us. That's all, my lord, that constitutes my that's what constitutes the concerns that my colleague here, Haj Obeid, and myself wanted to present to you. And as I have said, they are matters of very, very grave concern. We've been in jail for nearly a year now. They are not young people that can be easily adjustable. We have lost so much at a personal level that we would be doing. Yeah, so, my lord, I'm grateful that you have allowed us finally to present these concerns to you and to this court. In case the Judicial Service Commission has not extended our complaint to you, I have a copy here which we can gladly avail you, my lord.
That is actually English or large.
Order must be Haj Obeid, A1. Then Captain Ola, A2. That kind of
A1 is Besigye, A2 is
A1, you mentioned these concerns for this court. the same spirit. I pray that you at least accept the three nations' concerns for this honorable court. I so pray.
I would like to raise concern as pertain to my presence before this honorable court. And my concern goes to the issues of identity. According to the amended charge sheet issued to us on 29th of May, identity. According to the amended charge sheet read to us on 29th of May 2025, it is stated that 29th May 2025, charge sheet, amended charge sheet. It is stated that the particulars of A3, the 29th May 2025, 29th of May 2025. It shows that the particulars of A3 is RO 12 743 Captain Dennis Oola. Male adult Ugandan, 48 years of age, and attached to UPDF Armored Brigade. UPDF Armored Brigade. Much as we seem to share the service number, which is RO 12743, and the same rank 12743, and the same rank of a captain, my names, H, and even the unit are totally different. For proper identification, I am RO 12743, Captain Denish. It is DENISH Oya OYAA Oola. And I am 43 years old of age. Danish. Danish, which is DENISH, Oya Oola. I am 43 years of age, and I am attached to 5th Infantry Division of the UPDF. 5th Infantry Division of UPDF. My Lord, I would like to seek the guidance of this court. Whether this person it's actually myself or I'm being kept on behalf of another person. That's national ID and the military ID, you can furnish with the court.
I'm seeking for just a few minutes to do some consultation. Respond because I need to be really authentic and in my response. Say how much more? Maybe 25 to 30 minutes now. I'm just requesting for that.
This is just 12 minutes past midday. Seconds will take us to 1:44.
Yes, I put it one.
Quarter to one.
Yes.
Although you didn't ask us, my lord, we have no objection.
So I saw that they are submitting themselves, giving their concerns. So that's why I give the state to respond to the concerns. But you are given up to a quarter to one. Come back here.
It's most obliged to do.
Before you give them. So that you have to solve. So do you want to, we can't put the other file because he's appearing, because we have another file.
That friend is the same. Yeah.
It's in the same building.
Yes.
So are you suggesting we remain here as you was That's okay. Prison, is that okay? Yes. Let them
The court
go.
orders it is.
Arrangement. A1 raised the issue of the indictment. That the indictment reflects that they were committed to the International Crimes Division of the High Court. And that therefore, it is wrong for them to appear before this court. First of all, we appreciate that there was a typo error on indictment otherwise she was supposed to be the High Court of Uganda at High Court or at Kampala. My Lord, as the prosecution, we had taken note of it. And we were only waiting for an opportune time when the accused persons are ready to take plea to have that indictment or to make our application for leave to have the indictment amended under Section 51 of the Trial on Indictments Act, Cap 25. Under Section 51 of the Trial on Indictments Act, Cap 25. It is because we have been going through different applications that we were unable to make this application. Otherwise, my Lord, this High Court has unlimited jurisdiction. Under Section 14 of the Judicature Act. The International Crimes Division of the High Court is specifically supposed to handle matters of terrorism, trafficking in persons, international crimes, and international organized crimes, among others. That are spelled out in the legal notes that establishes the ICD. The charges with which the accused persons are indicted have no relationship with the charges that the ICD is mandated to try. The said typo errors, my Lord, that we also appreciate as the prosecution are not fatal. and did not go to the root of this matter.
We want to register our objection that the direction state is taking. They attempt to smuggle in an application for amending the indictment. My lord, they arrest. Yes, most of that.
So, my lord, I don't know if it's time. When this matter is fixed for retaking, we shall make that application. But our submission was that even before making that application for amendment, it is not true that the accused persons are wrongly before you, because you have unlimited jurisdiction. My lord, in respect to the issue of the Judicial Service Commission, or rather the alleged incompetence and bias it is a submission that prosecution has not detected any such signs of incompetence or bias on the side of the trial judge. My lord, the alleged complaint before that was filed in the Judicial Service Commission against the trial judge is not a bar for you to handle or for a trial judge to handle this matter, which is properly allocated to you unless the Judicial Service Commission has properly brought that matter to your attention, or the complaint, or it has determined it, or when it has determined it. In any case, this is not the first time we are hearing about incompetence and the issue of bias. When we were at Nakawa Chief Magistrate's Court, the applicants raised actually filed a complaint against the chief magistrate who committed the accused persons to High Court. Although, as prosecution, we were not, or we never got an opportunity to look through that complaint, the summary of it was raised by the accused's counsel that the trial magistrate was incompetent, biased. The only thing that has not been added here is the abuse of the process. What does this signify? It signifies the fact that the accused persons are serial complainants. But that said, my lord, we appreciate the fact that this is a matter that is between them and the court. Where prosecution can decide to be mute or to go mute. And it is a submission, therefore, that this court has a discretion to decide on whether to continue with the matter given the complaint before the Judicial Service Commission or if it deems it necessary that it is conflicted in one way or the other. That one is discretion of this honorable court. Otherwise, as a prosecution, we are more than ready to proceed in this matter because we believe that is where substantive justice is. In respect to, my lord, in respect to the issue of A3, we are surprised that the accused person did not raise this matter when the accused person appeared before the Chief Magistrate's Court in Akawa. But that's not to castigate him. As initially submitted, my lord, it is something which we can deal with in an application for amendment of the indictment under Section 51 of the Trial on Indictments Act, Cap 25. So to answer the question or the issue raised by A3, we shall make that amendment at an appropriate time when they are ready to take plea, because now to be premature, read my senior colleague Lukwago was uncomfortable even when I was not making an application to amend. So that means that we can't amend that now until the issue of readiness for trial is sorted out. My Lord, our conclusion, my Lord, is that this court overrules the accused persons on the issues they have raised. Because, like A1 said on the issue of miscellaneous application, that application is coming up. I believe it should have been raised in that application when it comes up. And say, you know what, my Lord, this was your decision in miscellaneous application 299 or 399. Now we believe that such and such a thing will happen in application number 282 of 2025. So it was a bit premature. That said, we pray that this court overrules them, and we have this matter fixed for scheduling, and we have it heard substantively. We are ready. We so pray, my Lord.
What perception? It must not only be done, but it must be seen to be done. And the simple question here is, in view of our client's indictment upon the court to the Judicial Service Commission, if you continue handling the matter, will the reasonable man with the perception of the reasonable man be that justice can be done in your court to the accused persons? My Lord, even with the seat of authority, judges do remain human. And are affected by issues that affect other human beings. So my submission is that on that alone, the court ought to recuse itself. But that is not all. On the issue of denial of mandatory bail from the eyes of A1 and his colleague A2, and it's called mandatory bail for a reason, because upon a set of circumstances being fulfilled, the court has no alternative but to grant bail. And those set of circumstances is accused persons having spent 180 days in custody, which A1 is reminding the court how it dealt with the matter, by stating that it had no record of the court-martial, the general court-martial proceedings. So even on that, those issues tabulated without going through what the A1 directed the court. Will the perception be that these three gentlemen can get fairness before this court? The perception is important because unless if subjects have confidence in courts of law, then law and order become under threat. The other very important issue raised is about the order from the Nakawa court to the High Court. Because it's an order. The order was to the International Crimes Division. A division separate from the division in which my Lord serves and in which we are today. This is the High Court Criminal Division. The order was the file be sent to the International Crimes Division. The lingering question, how did the file find its way here? Those divisions are administrative, set up by His Lordship, the Chief Justice. Was there perhaps an order by the Chief Justice transferring it from one division to another? Or are the divisions of the High Court allowed to take away files belonging to another? And if that is the case, what is the impression that would arise in the minds of reasonable people? How did it land here and why? Is the question. My learned junior, Mr. Biribumbuka, says that we are perpetual complainers. I will say we are very consistent on issues of fact, on issues of law, and rules of procedure. On that, we are consistent. And if he finds fault with that, then it is unfortunate. We do insist on our rights where the law is clear, whether it's mandatory bail or an order committing the proceedings to a different division of the High Court. My Lord, the whole scenario to us signifies a pattern of erosion of the right to fair trial, and that is what I got from our client's long address to the court, that he feels the right to fair trial, even on elementary matters such as mandatory bail, has been eroded by whatever is happening, beginning with the illegal rendition from Kenya. what I hear him saying is that this whole case is founded on illegalities, one illegality upon another. A court of justice should not have to act or give any color of right to illegalities. A court of justice should slam the door shut on illegalities for justice to be done. Finally, from me, not from our side, the courts failing to release them, even when the warrants of the court-martial expired. That is after the Kabasi Guruka ruling of 31st of January this year. Those warrants expired on the 3rd of February. Yet they were not released. They continued in custody. And the process continued going on without the courts acting on the illegality. That does make our clients aggrieved, and they feel that this case is a build-up of illegal actions. Not to mention the issue of territorial jurisdiction. The Constitution of Uganda is very clear. Courts of Uganda have jurisdiction within Uganda. The acts alleged were abroad. So even that itself becomes an illegality. Arrest without, it's 126, arrest without warrant in a foreign country, without due process. So those are the illegalities I heard our client going on about. So I would like I give way. I just want to end by referring the court to Article 129. It begins at 126, but the most instructive is 129. Judicial power of Uganda. 129. Courts of judicature. This is a court of judicature. Judicial power of Uganda shall be exercised by the courts of judicature, which shall consist. So what I want is just the word of Uganda, not of Kenya, not of any other country, just to indicate the territorial limits of your jurisdiction. So that when A1 says it is one illegality upon another, the court is able to grasp. I cede ground to my colleagues. I know that Lukwago and Kalibara and you.
May it please you, my lord. My lord, my land friend here, Mr. Besigye, labored to persuade you, albeit unsuccessfully, that there is a typo in the indictment, that it was a typing error. To say that the accused persons will be tried at ICD, that it was a typing error. That is the least I would expect from a state attorney of his caliber. With all due respect to my land friend here, my lord, and I dare say, my lord, my land friend was extremely dishonest in that submission. Extremely dishonest. And I will substantiate. my lord, if you looked at the record, that statement is in a court order signed by the registrar of the court. Signed by the registrar. It's not up to him as a state attorney to begin impeaching an order of court as being defective. It's not up to him. I don't need to advise him that if indeed that was a typing error, there is a procedure for court to correct its own record. Under the SRIP rule and all these other procedures. He knows. That has never happened, that this matter was ever brought to the attention of the lower court that handled the pre-trial processes, where this record emanates from. Nowhere on record it's indicated that they ever moved the court to correct its record. Never. Secondly, my lord, my reading of this, there is no typing error. The word, the phrase actually, that you will be tried on the above indictment at the sessions of the International Crimes Division of the High Court. Well structured in perfect English. International Crimes Division of the High Court, boldly stated, with no typing error at all. So it is disingenuous on his part to begin purporting at this stage that there is a typing error on record. Related to that, my lord, again, the submission he made that he finds no issues with this honorable court proceeding with a matter which was supposed to be transmitted to the ICD, which was committed to the ICD, because these are committal orders. The committal order is that ICD, that he finds no issue with the file being diverted to Rongo Division. I want to substantiate the submission made by Senior Counsel Martha Karua, the lingering question how the file found its way here. I'm trying to figure out, my lord, the clerk who got the file from Nakawa Court with the orders, take this to ICD. How did this clerk end up here? How? You are armed with a file from the lower court, the magistrate's court, deliver at the register of ICD. He or she decides to divert the file and bring it here. That speaks volumes about the propriety of the whole process we are trying to interrogate now. Then the last issue, my lord, on that particular matter, Mr. Birivumbuka submitted that these are all the same court. I mean, it's all the same. ICD and these criminal divisions, they are all the same. High court with unlimited jurisdiction. I wouldn't expect that from him again. I wouldn't. That submission, my lord, is neither here nor there. In other words, he's suggesting that actually a land matter can find its way here, or a family cause. There is a family division. There is a land division. My lord, can you handle land matter simply because it's high court or commercial transaction? So the instruments establishing these divisions of the High Court are redundant. They are made in vain, superfluous. For the record, my lord, ICD is a creation of the law. It is the Constitution, the High Court, in bracket, International Crimes Division Practice Direction, 2011, and in the recital there, my lord, you will see, made under Article 133, Clause 1A and B of the Constitution of the Republic of Uganda. The High Court, International Crimes Division Practice Direction 2011, made under Article 133, Clause 1AB of the Constitution of the Republic of Uganda. And in Clause 3, Paragraph 3 of that practice direction, establishment of the division. The division established in 2008 under the War Crimes Act, no, under the International Criminal Act, International Crimes Act rather, as the War Crimes Division, is hereby designated as the International Crimes Division. And my lord, there are rules, specific rules regulating the processes or the procedures before that court, which are totally different from the rules governing this court. And that is the Judicature, in bracket, High Court International Crimes Division Rules of 2016. They are quite elaborate and detailed rules. I don't want to labor you, to waste your time, my lord. And my lord, the peculiarity of this court, the uniqueness of this court, is not only seen in the processes and procedures provided for under the rules, but even the composition of the court. My lord, the practice direction which I have just cited clearly indicates that there are situations where the court can sit as a panel of 3 justices of the judges of the High Court, which is not the case with the High Court Division here, the High Court Criminal Division. It's not the case. Here it is constant, one judge in all these cases. But International Crimes Division, there are cases where, or rather, there are cases that it may require a panel of 3 judges. Who knows that maybe this could be one of them. He indicated that Mr. Birufumba submitted that the jurisdiction of the other court is limited to war crimes, genocides, crimes against humanity, and terrorism, and so on and so forth. But I would like to draw your attention to paragraph 6 of that particular direction, practice direction. Without prejudice to Article 139 of the Constitution, without prejudice. So this particular instrument is predicated on the provisions of Article 139, which talk about the jurisdiction of this court. That the division shall try any offense relating to genocide, crimes against humanity, war crimes, terrorism, human trafficking, piracy, and any other international crime as may be provided for under the Penal Code Act Cap 120 or Geneva Convention. Any international crime. And when you look at this instrument, the particulars, they are indicating this is a cross-border crime. Kenya, Geneva, Switzerland, wherever. That could have been the reason why the lower court deemed it necessary to refer this matter or to commit it to the ICD, which is well suited to handle those matters, my lord. For your case, my lord, your jurisdiction is restricted here. You can't handle international crimes. You cannot. But for the ICD, they have that mandate to handle international. For the record, by the way, it was established for that particular purpose, cross-border crimes. So I want to conclude, my lord, to wind up my submission on the issue he raised, that they intend to apply for an amendment. That is not a matter to be raised here. No. Actually, my lord, that shouldn't even be considered at all. Their intention, they are giving you a notice that they intended to amend. If they wished to do so, they know what to do. So must this court proceed with an illegality as they wait for the state to effectuate their intention? And even if it was a typo error, a typographical error, would they want to suggest that actually the whole Directorate of DPP is that incompetent not to detect that mistake up to this particular moment, that they could not correct it at a lower court? And they want to smuggle in an application here where you do not even have, this court is not clothed with jurisdiction to entertain such matters. Those are matters to be handled at a pre-trial level before the Chief Magistrate Court, if they so wished. So there is no need of citing Section 51 of the TIA here. No need. It's not this court which prepared this indictment. No. It's the lower court. So we reiterate the prayer, my lord, that you be pleased to allow this file to find its appropriate destination where it was supposed to be dispatched. Maybe this was a stopover on its way to ICD. Its itinerary is very clear. From Nakawa, maybe pass here briefly to CID. Let the journey continue up to its final destination. We do so, pray, my lord.
That constitution introduced and has maintained the right to a fair trial in a language that is so clear both in its purpose and in its effect. Lord, the specific article is 28. It speaks about impartial tribunal. Independent and impartial. I know the Constitution did not just stop there, because in Article 44C it also provides that the right to a fair hearing cannot be derogated from. There are no circumstances at all, any nature, in the law, in practice, wherein that right can be derogated from. My Lord, what I hear the accused raising which is consistent with their duties as citizens, to safeguard the rule of law. Is that they apprehend that this right is enjoyed by them, not by the court, by them. Is in the kind of danger that Article 44C sought to ensure does not manifest at all. My Lord, their duties are in the national objectives and directive principles of state policy. I think it is 29 that deals with the duties of the citizen. So, my Lord, my land friend for the state may not have fully appreciated what is at stake here. It is not a light moment. It is not just an opportunity for the accused to speak to the court. But it is the accused putting on record their real and palpable fear that they will not get justice if the court, as constituted, continues to deal with this matter. My Lord, this court derives its power from the people of God. And it is enjoined to exercise that power in accordance with the values and the norms and the aspirations of the people of Uganda. The accused are part of the people of Uganda. It cannot be one of the norms or among the values or aspirations of the people that where there is a pending complaint of the nature described by A1, that this court could still be seen to be independent and impartial. Lord, when I look at this audience in the court, I see one individual who is from my memory. Who is in this court who participated in making this constitution? And his signature is on it. If we were to find the original version, we would find his signature. He is A1. So he raises issues that are pertinent to him, both from a historical perspective and from an aspirational perspective. And from his experience over the last 1 year. Last 10 or 11 months. A lot on the question of the type. I just want to say one small thing. When I read the indictment, I don't see my land friend's participation in it. Signing, naming, drawing, anything. What you need to say that he was part of. So he really can't explain the preference for ICB stated in that document. He can't explain it away as a type. It is a preference, a choice. It has no relationship with the document to say anything about it. Like my colleagues have submitted, it is not. So his explanation cannot repair or fix that very fundamental issue, which is the submissions of A1. It's part of continuing illegality. I'm glad that counsel for the state did not oppose the submission made by A1 about his illegal rendition. To deal with this matter if it affects that constitutional order. Of all days, not today. The court cannot shut its eyes to the constitutional order, to the right to a fair hearing, the issues being raised by the accused. My Lord, we leave it to the court to make the kind of decision that my learned friend for the state has said is within its discretion. To bear in mind that Article 28, Article 44, read together with Article 126 of judicial power, require that the correct thing to do as my land friend has submitted is to save this file to its preferred destination, its original destination. Along the rights of the accused, the sanctity of the court, the evidence with which we hold our courts, will be protected. But most importantly, the rights of the accused will be assured. My Lord, I rest my submission.
Grounds to use their own words of gross incompetence. And what I'm providing here is simply the legal basis for their request. And Lordship, a very pertinent reminder that it is your obligation to enforce the provisions of the Constitution and give them life and meaning. Lordship, there is a statement that came from the Constitution that you put to an answer when he said that the accused are perennial complainants.
In fact, I've been one, I use a different word, it's never on the record. Two, there was no application for victim in this regard that necessitated my brother to respond to. 4, there was no application to have you removed from your position as a judge They simply say they filed a complaint at the Judicial Service Commission, which among others seeks to. So we cannot be hard to say that the accused persons want you out of your office. So ordinarily shouldn't be something that my brother should be responding to. Just a minute. I've just been patient. And my Lord, I pray that even if I seek you to respond to the arrest, that should be expanded from the record. Because it shouldn't have even come up at any point. Because as a prosecution, we never responded, we never said anything about that. And the rules of procedure are very clear. That you can only make a rejoinder on what was said in response. Did we mention anything to do with the victim's application? Did we mention anything to do with an application to have you removed from office here before court? Did we say anything about perennial? So I think as we proceed, we stick to what we said in our response.
Thank you. It takes patience to listen to Richard. We didn't use it where it is. We are hearing about incompetence and bias, not for the first time. He also said the accused are serial complainants. So I think basically his misunderstanding. He doesn't know synonyms of serial. But my response to that is this: that for as long as the accused are victims of bias and incompetence, it is their duty and also the duty of the lawyers to raise it before this honorable court or any court in which they appear. And also as to what he called much earlier, he tried to dispute the incompetence of the trial magistrate, but the Yorkshire referred you to the record of Nakawa, and you will see that
Can we proceed?
yes, my Lord, I'm proceeding. Unless you want to tell me how to proceed, but my Lord, I'm proceeding.
I'm saying proceed and answer the question.
Yes, one of the concerns he was disputing, Your Lordship, was the incompetence of the trial magistrate. And this is my response to it. I'm responding that the incompetence of the trial magistrate drips the pages of the trial record in Nakawa. It's all over. So the prosecution cannot wish it away. With those few remarks, Your Lordship, I will invite my colleague.
Next week. Yes. Besigye bakusatu. Bakusatu. Wokuna.
Filing here, my lord, and it's feel that in view of the issues raised. Particularly by A1 and A2, that this application ought to wait your ruling on the matter that has just been reserved for the 15th. The issues are the same. Yes, my Lord, maybe it can be emphasized a little more by Mr. Karibara, but they have objected to your proceeding with the matter. Is the matter before you? Issues are... Yeah. Okay. Yeah.
Where I said the refusal was made and there is a ruling. Second, the refusal was made. I don't think it's the application.
Okay. I yield to my learned colleague.
The issues raised regarding view of the issues raised regarding the court, the main case, the session case under 325, session 325, clause 25, which particularly touch on the fair hearing. This application that planned await court's ruling this session case. From that ruling, then know how to proceed this particular application. The suggestion from us is that we mention the same thing in 15th October, so that we are then able to know how to
We see no nexus between this application and the main trial. Reason being that the applicants made almost a similar application, for recusal. And the ruling was made. The trial judge pronounced himself on that application. And my Lord, in the previous adjournment, my senior colleague Elias Lukwako, Lord Mayor, wanted to resurrect the same application, which had been dealt with prior, and the court overruled. In fact, in as far as the respondent is concerned, this application was coming up today for schedules. It will be legally fatal, my Lord, to relate this application and the main case. because the circumstances are completely different. In the main trial, my lord, that had just been, in the main case that had just been adjourned, there was nothing like this application that was made in that main trial. And whereas in this application before you now, my lord, this application was made and the court pronounced itself. Therefore, prosecution submits that this matter, the court should go ahead and give us schedules. Give parties schedules. So that, my lord, we file our submissions. Otherwise, it looks like the applicants are not ready to have this application heard. In which case we shall be compelled to make an application to have it dismissed. That is if they indicate to court that they are not interested in having it given schedules for submissions. Because prosecution is ever ready. So in the circumstances, my lord, we pray that this court gives us schedules and we file submissions. There is no need for an adjournment in this matter. We so pray.
Submission. And it is as if he wasn't here when the question of apprehension of an unfair hearing arose from the accused person. It was as if he wasn't here when the accused said they had lodged a complaint at the Judicial Service Commission for a specific purpose. It was as if he wasn't here. Because, my lord, in that complaint which I have perused, this is the danger of objecting. You must now go into the complaint. The accused have a real apprehension. These are the statements in the complaint. They have a real apprehension that miscellaneous application 282 of 2025, which is pending before your lordship, cannot be judiciously considered. I know the apprehension is not a hat which they wear in the main case, take off in another application, where part of the apprehension comes out of the way which the miscellaneous application 399/2025 was dealt with. So it is a bail application like this one. Mandatory, but bail mandatory. This is a discretionary bail application. The apprehension is still there. So our suggestion is that we will leave it as a suggestion. So I don't expect Mr. David to follow about it. That this application awaits your lordship's decision. The main suit. The schedule will mean that we are here in the application in the face of that apprehension that is going to be don't know whether it's hard to appreciate the accused person's position. My Lord, also just to put it on record, we will be seeking to argue it forward. So not directions for written submissions, but we will wish to argue it forward when we get to that stage.
Application is adjourned for nation.
I am most obliged.
Today, the court allowed Dr. Kizza Besigye to raise his complaints orally in open court. He has raised them very well. I do not wish to summarize because I'll be diluting. You have the clips. Let the people of Uganda know what the issues he and his colleague Lutale and even Captain Ola have raised today. The case has been adjourned to the 15th of October when the court will make its ruling. But one of the issues I can say was his recusal. Yeah.
Dr. Besigye raising ensonga 3 ne Ola naye na raising ensonga yemu ensonga 4 nga za muzinzi era nga ziraga nti wano bino bye balimu bya kimenya mateeka bigenda maaso. Ensonga 3 eza Dr. Besigye zaleese esooka kwe kulaga nti bamujje Nairobi ne bamuyisa ku boda ne bamukomyawo mu bumenyi bw'amateeka. Amateeka agaffe gakirambika bulungi nti omuntu gwe bakidnappings oba gwe bawambye okuva mu ggwanga eddala n'omukomyawo wano tosobola muteeka mu mbuga z'amateeka n'omuvunaana. Era eyo ensonga nkulu nnyo Dr. Besigye agiggyeeyo. Eyokubiri, Magistrate Court e Nakawa yagamba nti Dr. Besigye atwalibwe mu ICD, International Crimes Division, eyeteekebwawo etteeka ddamba erina n'agikulira n'abalamuzi. Era waliwo wekyetaagisiriza ng'erina kutuuza pano y'abalamuzi 3 ng'omusango munene oba gulimu ensonga nnyingi ne baga nti omuntu ajja gisobola oba fayiro tajja gisobola keesi eyo bateekewo abalamuzi 3. So ICD, International Crimes Division, fayiro gyeri. Kati ensonga eri eyebuuzibwa nti fayiro gye baweereza mu ICD ejja etya wano, baguma yagifuna atya, bagitikka bakiraaka bagitwale mu ICD, ani yaginterceptinga mu kuba awo n'agiyimiriza n'agidivertinga n'agireeta mu kooti wano. Ensonga eyokusatu no mbufunze ngalaga nti nti wano ali mu kooti nkyamu. Dr. Besigye ne Obedi ne Ola bali mu kooti nkyamu. Omusango guno gwina kubeera mu ICD so si wano. Ensonga eyokusatu y'okugamba baguma nti ali incompetent, nti tasobola wamunguba muntegere y'amateeka tagategeera bulungi era tajja kusobola kuwa bwenkanya olw'ensonga nti engeri gy'azaakwatamu ensonga zino ziragira ddala nti abulamu nnyo omutindo ogwetaagisa omulamuzi. Ate nga ssemateeka alaga mu atika y'ekikuminaana nti omulamuzi bw'obanga totuukiridde mutindo ogw'okuteekateeka n'okulamula obulungi osobola okuggibwa ku bulamuzi. So Dr. Besigye yateekayo musango gwe mu Judicial Service Commission ng'agamba ekitongole ekyo kubanga kyekikangavvula abalamuzi nti ono mukulu baguma gwe muweereze n'okulamula abantu omulimu tagusobola, amateeka tagategeera bulungi. N'olw'ensonga eyo Dr. Besigye ng'agamba tasobola kugenda mu maaso baguma ng'awuliriza omusango ng'ate ne Dr. Besigye amuvunaana mu Judicial Service Commission oba akakiiko akakangavvula abalamuzi. N'olw'ensonga eyo ng'agamba baguma omusango aguveemu kubanga naye yennyini amuyina Dr. Besigye amuwaabira omusango obadde ebbali. So ezo nsonga ssatu. Mukulu ola n'abanga ye ensonga ye gyaleese yakugamba nti wano baleeta muntu mukyamu mu charge sheet. Gwe boogerako ye Dennis Ola yali mu charge sheet. Naye ye nga yagamba ye Dennis Ola. Era gwe boogerako mu indictment oba mu mpaabi nga wa myaka 48 mu kiwandiiko kya state ye ng'agamba ye wa myaka 43. N'olw'ensonga eyo gagamba oli gwe boogerako Ola Dennis mulala era nga ye yennyamira nti agamba amaze ebbanga ligenda kulaala emwaka mulamba ng'ali mu kkomera yeebaseeyo ku lw'omuntu omulala gwe bataakwata era gwe bataaleeta kati ng'alaga nti waliwo obutali bwenkanya gy'ali. Kakati ensonga ezo state bwezizzeemu mu ngeri gyezizzeemu mukulu Birivumbuka omulamuzi kwe kugamba nti ajja kuwa ensala ye ng'ennaku z'omwezi 15. Waliwo bail application era tumulaze nti yagaana mandatory bail n'alemesa Dr. Besigye okuteebwa n'agamba nti ye bya General Court Martial yali tabimanyi by'okumusiba nti therefore n'ennaku 18 zaali tezinawera bamukomitingira nga 29 ogwokutaano n'amumma bail. Tumugamba nti kakati era mu ruling eyo mukulu baguma yennyini n'agamba nti ye kyalaba Dr. Besigye ne banne balivudde mu kubonaabona n'okwetalirira kooti nti basaba bail batunulire kimukuuliriza main case n'abanga bail alinga eyagisala edda obanga abalaga nti ne munaamala ebiseera nga musaba bail mumala byambulago tebagenda kubawa bail. So nga tumugamba tasobola kugenda mu maaso nakulira application eyo. State ye badde eremerako ntugende mu maaso naye asazeewo nti ejja kujja ku 15 ku mention si kuwulirwa 15 guno naye mention kujoogerako bwogezi tulabe ekinaaba kizeeko. So katulinde ku olwo ensalawo bwe naabeera.